Manik Taneja versus State of Karnataka. This is a judgment which was decided by Justice V. Gopalagoda and Justice R. Bhanumati of Supreme Court of India. The case was decided on 20th January 2015. This case is relating to a post on Facebook. In this case, the appellant number 1, who is Manik Taneja, and his wife Shakshi Java met with an accident with an auto rickshaw. While Shakshi Java was driving Maruti, one of the passengers who was traveling by the auto, namely Mrs. Lakshmi Ganapati, sustained injuries and she was duly admitted in the Santosh hospital for treatment. Shakshi Java, the appellant number 2, was said to have paid all the hospital expenses of the injured, and the matter was said to have been amicably settled between the injured and the appellant, and no FIR was lodged. The constable, who was present at the time of incident, directed the appellants to meet Mr. Qasim, police inspector, Pulakeshi Nagar Traffic Police Station, Bangalore City. The appellants allege that as soon as they entered the office of Mr. Qasim, he behaved in a rude manner. Further, Mr. Qasim summoned the appellant number 2, Shakshi Java, to produce her driving license and other documents. As at that time no FIR was lodged, the appellant number 2 questioned the police inspector as to why she was being asked to produce those documents. Mr. Qasim, in reply, was alleged to have threatened appellant number 2 by saying that he would drag her to court if she continued to argue that she was also thrown out of his office. On the orders of Mr. Qasim, his deputy told the appellants that they are booking them on the charge of rash and negligent driving. Being aggrieved with the manner with which they were treated, the appellants posted comments on the Bangalore Traffic Police Facebook page accusing Mr. Qasim of his misbehavior and also forwarded an email complaining about the harassment meted out to them at the hands of the respondent police inspector. The respondent number 2, police inspector, filed a complaint regarding the posting of the comment on the Facebook by the appellants, and subsequently FIR was registered against the appellants for offences punishable under section 353 and 506 of Indian Penal Code. The appellants filed criminal petition under section 482 Code of Criminal Procedure before the High Court, seeking to quash the FIR and the criminal proceedings initiated against them on the ground that the complaint is an afterthought. While this case came to Supreme Court observed that the allegation was that the appellants have abused the complainant and obstructed the second respondent, that is police, from discharging his public duties and spoiled the integrity of the second respondent, Mr. Qasim, police inspector, Pulakeshi Nagar Traffic Police Station, Bangalore City. From the facts and circumstances of the case, it appears that there was no intention on the part of the appellants to cause alarm in the minds of the second respondent, causing obstruction in discharge of his duty. As far as the comments posted on the Facebook are concerned, it appears that it was a public forum meant for helping the public, and the act of appellants posting a comment on the Facebook may not attract ingredients of criminal intimidation in section 503 Indian Penal Code. In court view, the appellants might have posted the comments online under the bona fide belief that it was within the permissible limits. As per court, none of the ingredients of the alleged offences were satisfied. So, the court decided that posting a comment on the Facebook may not attract ingredients of the criminal intimidation as per the fact of that particular case.